Would you ask Mr. Martin to come back in, please? All right, Mr. Martin, ready to carry on?
Yes, sir.
Thank you very much. Yes, Mr. Miller?
Yes, Mr. Chairman, thank you. Mr. Martin, can we go back, please, to your September 1999 report to North Ayrshire Council at BRE 3035377? We looked at it before. It was the one you co-authored together with Penny Morgan and one other. And if we go in that, please, to page 10, we looked at this before when comparing the two reports, and you can see there, just to remind you again, first, you can see the reference to Class Naught in the hanging paragraph, second on the page, yes?
Yes.
And also the suggestion, we suggest that non-combustible materials are chosen wherever possible. Now, first, was that your view at the time? That was your suggestion at the time?
I don't remember.
You put your name to this report, so can we take it that you agreed with everything in it?
I guess at the time I would have agreed with everything in it. Whether I still do now, I don't know.
Well, that's what I'm asking you.
Yeah.
When your name appeared on this report, can we take it that you assented, you agreed with everything in it? Whether or not you actually wrote everything in it, you agreed with everything in it?
I suppose that's fair, yes.
Well, is it the case? Maybe fair, but is it right?
I can't remember, so I can't
Right.
say for certain. And maybe I did disagree with some of it, but I don't remember.
Well, you would have said, presumably, and you wouldn't have allowed it to go out with something under your name if you disagreed with it.
I assume so.
Yeah. Now, that being the case, can we take it that you knew by September 1999 that Class Naught was an unreliable metric or classification for the control of fire on an external surface of a high-rise building?
No.
Why is that?
I don't think I would have thought of it in those terms. And as a control of a surface, I think it's still not an unreasonable control.
Well, you think it's not an unreasonable control. What was the basis for your suggestion, or the suggestion to which you assented at the time, let it be assumed, that non-combustible materials be chosen wherever possible?
I guess it's the safest option. It's the least complex option available. So I assume that. I don't remember that line being drafted. I don't know if I contributed to that or not.
Right, but can we take it that, given that it's the safest option, in the context of this fire, and particularly Class Naught and its presence, that you regarded non-combustible materials for the external wall as the safest option, and by that same reasoning, Class Naught as not as safe?
Yes, I guess so. Yeah, I mean, I don't think I would have thought of it in those terms, but
No.
the less, if you've got a choice between something combustible and something non-combustible, if you can pick the non-combustible one, is a obvious conclusion.
Yes. Was not the suggestion here that non-combustible materials be chosen wherever possible advice well, at least an opinion, that ADB needed amending?
I don't remember that being something that we discussed at the time. Looking at the paragraph in total, it looks like a reference to the specifics of remediating that particular building.
But doing so, is this right, would mean that it was, the remediation would go well beyond what ADB required. Because, as you, I think, agree, ADB did not require non-combustible materials to be chosen for the external wall.
That's right.
Did that suggestion not mean that if it was going to be carried out on more than one building, in other words, a generic suggestion, that ADB would need amending? It would do, wouldn't it?
Yeah, I don't recall having that conversation with anybody. I think there's a difference between what you might recommend to somebody as being the safest option and a minimum standard that you might enforce.
Why did you not simply suggest that if, and to the extent that the external wall system at Garnock was non-compliant, that it be replaced with a compliant system, that is, a Class 0 surfaced external wall?
I don't remember.
Is it the case, in fact, that you realised at this point, in making that suggestion and in the references to Class 0 that we've seen, and in particular the reservations about Class 0's current performance in the paragraph before, that you knew by this time that which Dr. Smith had told us in paragraph 24 of her statement we saw earlier, namely that Class 0 itself was an inadequate measurement as a control of external fire spread?
I don't think I had concluded that at that point. I was still a relatively sort of junior partner in the team that was drafting this. So I don't remember coming to that conclusion at that time. It may well be that perhaps the other members of the team who are more experienced than me did think that. I don't remember that being a conversation.
Now, at this time, you were both at the BRE and at government. As a matter of fact, on the assumption that you were signing up to this report, happy that it should go out with your name on it, does that tell us that there was somebody in government, i.e. you, who were of the view that Class 0 was something about which there were reservations, and that it was preferable to have non-combustible materials in the external wall where possible?
I'm not sure I'd jump to that. I'm not sure I'd come to that conclusion. That's not what I remember thinking at the time.
Did you ever tell Anthony Bird that back in September 1999 you had signed a report which expressed reservations about Class 0?
No, I don't remember this conversation, so I wouldn't have raised it with him because I don't remember it.
No, but you would have presumably remembered writing the report or being party to it. It's got your name on it.
I certainly remember the incident. I've probably written a lot of reports over the years.
Well, this is one of the landmark reports, or one of the reports about a landmark fire, which then gave rise to a select committee investigation, didn't it? So this was quite an important report, yes?
Yes.
And my question again, you wouldn't have forgotten about its contents and the relevance of Class 0 and the suggestion about the use of combustible materials in it, would you? It's not something one easily forgets.
I can only tell you what I can remember. I
Right.
don't remember.
So just to be clear again, did you at any time in September 1999 tell Anthony Bird that you had written a report which contained reservations about the performance of Class 0 and the suggestion that non-combustible materials be used as a remedial measure in the Garnock Court fire?
No.
In the Garnock Court building? No. Why is that?
Wasn't a conversation that occurred.
Right. But you could have done. You could have done, couldn't you? There was nothing stopping you telling him.
No, nothing. Yeah, if it was something that I felt was appropriate, I could have raised it with him.
Right. Did there ever come a time in all the years after September 1999 and the 14th of June 2017 when you considered Class 0 and its limitations and the desirability of non-combustibility in the rain screen, in the external wall system, that we see expressed on this page here?
Probably not until after the Edge fire in Manchester.
So you addressed it in your mind then, did you? We'll just take that as a milestone in the history. This is a time when you look back to 1999 and thought, is this right? Class 0 is not.
Oh, I didn't refer. I'm just thinking, in terms of concluding that perhaps a more onerous provision was necessary. It was following the Edge fire, I think, was the next time that I gave this any consideration.
Very well. Now let's look a little bit more closely at the role the cladding played in this fire.
Mr. Millett, before we leave this page, which I suspect we're about to do,
Yeah.
I think in fairness to Mr. Martin, I really ought to ask him to comment on particular words, some of the particular expressions used here. In the second paragraph that we've been looking at, one that begins, although the material used in 1991. You see that?
Yes.
I notice that the word current is used. We have reservations about its current performance. And if you go down to conclusions and recommendations, number 5 reads, we suggest that we consider that the GRP in its current aged state may not have met the Class 0 specification. Does that ring any bells with you about the investigations that may have been made into the GRP cladding?
Not specifically, no. I think this may have been caution on the part of whichever one of us wrote this paragraph, that you might well think something's not Class O today, but you can't be certain that it wasn't Class O when it was installed. There are some fire retardants tend to leach out of a material over time. It's a problem for a number of different materials and a number of different behaviours as well, not just fire. Plasticizers in plastics tend to leach out after a while, which is why plastic products become brittle when they get old. So it may have been, so whoever wrote this paragraph, and I don't know who it was being careful not to categorically say this product failed to comply with the rules that applied to it at that time, because you couldn't categorically say that was true.
Well, I thought it right to show you that, because questions have been put to you on the basis that this report demonstrates a recognition that Class 0 was not a satisfactory measure to use under any circumstances, so to speak. And I wondered whether, in fact, the thrust of this is more on this cladding in its aged state.
I think our honest opinion at the time is it probably never was Class O.
No.
To my mind, looking at the stuff, as it looks like the stuff you'd repair a car with, there was clearly no attempt to use anything even slightly fire retardant. No one had given fire safety a second thought, I suspect, when it was selected as a material.
Right.
And so I think our thinking at the time was that this demonstrates what happens if you don't use a Class O product. I wouldn't say that it demonstrates that we didn't think Class O was adequate. I don't think the evidence was there one way or the other from this particular fire.
No. All right. Thank you very much. Well, do you want to follow?
Yes, I do. To be fair to you, there are two ways of reading that middle paragraph. One is about the current performance of the material, and one is about the current performance of Class 0. And I think the point that the chairman was putting to you was that the other way of reading it is about the performance of the material, and that links with what's said in the first sentence of paragraph 5. There's a further question, I think, that arises, which is this. Was it your view at the time, looking at the Garnock Court experience, if I can put it that way, that although a material of Class 0 might achieve Class 0 as an adequate measure of fire spread on an external wall when applied, the problem is that certain materials which achieve Class 0 when tested degrade over time and therefore stop being Class 0 if tested later? And therefore Class 0 itself is not a reliably permanent classification.
Well, I think any classification is potentially unreliable. It's not specific to Class 0. If a material degrades over time, all its classifications may become invalid. I think that's the point that we were getting to there. Not necessarily saying this has degraded, because we wouldn't know, but that it could have degraded, and we had no evidence one way or the other to say as much.
Now let's look a little bit more closely then at the role of the cladding in this fire. Can we go then to the 2000 report, which we saw briefly at BRE 3035377, page 22. This is where it starts. And you can see, well, you can't yet. Yes, you now can. April 2000, signed in May 2000 by Nigel Smithies, authored by Penny Morgan. And if we go to page 24, items 2 and 3, it says this. It's highly unlikely that the material used as cladding for Garnock Court and the 4 sister blocks was Class 0 at the time of the fire. It is also highly likely that the GRP supplied would never have achieved Class 0. Now, do you remember, what was the full product name of the GRP panels used at Garnock?
I don't think it was a it looked. All I saw was the material that I've repaired cars before, and I've seen scouts making canoes out of. It was very basic glass fibre material where someone's used sheets of fibrous material, and then you coat it with several layers of resin. The resin goes hard, and you end up with a glass reinforced plastic. So I don't think it was factory produced on a large scale as a construction product.
Do you know why the product name and identity of the manufacturer are not included in the report, either of the reports that came from the VRE?
I don't think we knew what it was.
Well, I know, but why not?
Because probably no one knew what it was.
Could you not have investigated?
We would have asked the building owner if they knew what it was. And they clearly didn't know, otherwise we would have put that in the report.
Right. But identifying the manufacturer and the product was key information, wasn't it? Particularly for the government, when it came to it, who may want to investigate whether or not Class 0 was being claimed for products which had not in fact achieved it. No?
If there was any evidence that it was claiming Class O, then it would have done. But I don't think there was any record that said one way or the other.
Well, that's the problem, isn't it? If you look at conclusion 3, it says it's also highly likely that the GRP supplied would never have achieved Class 0. That's a matter of grave concern, isn't it?
But it demonstrates that someone didn't specify the right product at the time.
Can we agree at all events that the testing carried out, or the investigations carried out, showed that the central issue, the key point at Garnet Court, was that the cladding panels were unable to meet the relevant building regulations and guidance?
I should add, it was in Scotland, so the Scottish building regulations applied.
Yes.
But they were quite similar at the time to the English regulations.
I mean, can we take it that there's no difference between English Class 0 and Scottish Class 0? I think there's a difference in name, but no, not in standard.
At that time, Class 0 was definitely the same in both.
Yeah.
And presumably you were aware that somehow it had got through building control, or whatever the equivalent Scots system is.
I don't think we investigated that to any great detail, sir. I think the nature of the work that we did for the department and the contract that still runs now is quite limited in its scope. We've got no powers of investigation or enforcement. And if we were looking at an issue here where one might argue that someone has breached the regulations and as a result it's resulted in a fire, that's an offence that an enforcing agency, whether I don't know, whether it be the police, training standards or building control, would be involved in. So we were quite limited in what we could find out, and it tended, other than looking at the fire scene, all you could really do was speak to those relevant authorities or bodies that were willing to talk to you. And quite often people aren't willing to speak to you because they're probably expecting to find themselves in court at some point.
Yep. All right. Thank you.
Now, we looked at the discrepancies between this report, the September report, and the August report as given to government. Can you think of a reason why the report given to government didn't clearly articulate the concerns that you and Penny Morgan had about Class 0, if that was a concern, or about the ability of the external panels to degrade and then fail to meet Class 0 over time, or the suggestion that the external wall build-up should be comprised of non-combustible material if possible? Why was that never communicated to government? Do you know?
I can't remember what the conclusions were of the report that was communicated to government, but there's no deliberate attempt to share one sort of information with one customer and one with another, not that I'm aware of.
Right. You see, I think only you and Penny Morgan are able, you're the only people who could know that these reports, the September 99 report and the August 2000 report, were discrepant in the way I've shown you. That's right, isn't it? You're the author with her.
And I guess Nigel Smithies might remember as well, I don't know.
Well, now Penny Morgan can't recall. We've asked her why it was discrepant, and I have probed you before, but can you think of any reason why these very deliberate, very precise excisions were made?
No, it seems strange to me. I don't really understand why they would be different.
Well, it seems strange to us, and you're the only person left I can ask.
I agree. I have no idea.
Do you remember whether there was any recommendation or research done into these GRP panels to find out what testing had been done on them, and what the advertising for those panels asserted in relation to their fire performance?
Not that I'm aware of.
Why is that? Why was that not done? Do you know?
I think if anyone would have done that, it might well have been North Ayrshire Council, if they'd wanted to take action against whoever specified and provided the product.
But you don't know yourself?
No.
And the government doesn't know, presumably, because you didn't explore it further with them, with your bosses?
No.
And does that lead us to the conclusion that it's entirely possible that the GRP panels would continue to be sold as Class 0 panels and installed on buildings on that basis?
It's conceivable, but I've never seen that product ever sold ever anywhere else.
Well, that's as a result of later experience. My question is a slightly different one. Having discovered that a high-rise building, a domestic residential high-rise block of flats with occupants, was clad in materials used by Boy Scouts for canoes, why did the department not undertake an investigation to get right to the bottom of how come this stuff ended up on this building, how it had been sold, how it had been tested, to make absolutely sure that that fire never happened again?
I think that would have been a matter for the Scottish authorities.
Well, I'm asking you, can you explain why that didn't happen?
No, I don't think I can. I'm pretty sure the Scottish authorities would have been informed. I don't think anyone investigated it further.
But you were working in Eland House part of the time and Watford part of the time, firmly in England, and the report that went to Anthony Bird was not solely about Scotland, but you had written or helped to write the first report, which expressed the concerns we have in it. So was it not a matter, in your mind at least, for serious investigation by UK government, the department in which you sat half the week?
So what I can remember, I think the thought process that was gone through was that here was an installation that did not comply with the guidance that the English authorities department was responsible for, and demonstrated why it was important to comply with it. I think it would have been a different matter if it was demonstrably compliant and still the fire spread. I think the department would have taken a different view on it.
So the problem is, without conducting a proper investigation, the government, our UK government, couldn't know whether this was a one-off act of non-compliance with a very peculiar material chosen in one-off circumstances, or more widespread, could it?
Yes, I think you're right.
Nor could it know whether or not it was an unfortunate event because the person carrying out the work had relied on a misstatement by the manufacturer as to the class of material, or whether, in fact, there was no stipulation as to class. You didn't know that either.
Not that I can remember.
No, and I'm just asking you, as the person who knew what was in the original report, why there was no such investigation, given that you were part of government as well at the time.
I was a part of government. I was a contractor working for a team in a government department. It wouldn't have been me that decided to extend an investigation further. Although if there had been a conversation, I'm sure I would have been involved in that. Was
this one of those things that you didn't feel you could pass on to Anthony Bird? Didn't feel you could tell him about the reservations I've shown you in the 1999 report?
No, as I say, I think the thinking at the time amongst the people I was working with was, here was something that didn't comply, and it demonstrates that people should comply. And I don't recall any conversation about trying to track down the manufacturer. I think it was kind of patently, obviously non-compliant. So it was more, and I can't remember at the time whether there'd been a building control application or not, or whether even one was required in Scotland at the time.
Now let's go to the August 2000 report to government, please, at BRE 303535, page 4, and look at the second paragraph underneath the fire, the heading "the fire," and it'll be familiar to you because I think I've already read it to you. In the earlier version, the brigade were called at 12:50. You see that?
Yes.
And I think we've already looked at that. Now, you can take it from me that this is the only substantive technical commentary on the role of the cladding on fire spread at the Garnock Court incident in this report. Do you know why that is?
I'd need to read the whole report a few times to get to the bottom of that exactly, but I suspect it's because it's an uncomplicated issue.
Right. Do you know why the fact that the cladding was fueling the fire at the top of the building is not stated in clear terms?
Fueling the fire at the top of the building?
Yes.
But it was the mechanism for fire spread. The fuel for the fire would have been the cladding and the contents of the flats.
Do you agree that the UPVC window frames significantly contributed to the rapid fire spread of the fire and its entry into the upper floors?
Sorry, where does it say that?
Well, it doesn't. But do
Oh,
you
right,
agree?
well,
That's the point.
What I've seen of UPVC windows is they tend not to contribute greatly to the spread of fire.
I mean, do you agree with this, that the presence of combustible GRP spandrel panels was the primary contributor to the rate and extent of the external vertical fire spread?
Yes.
Yeah. Now, after Garnock, did you consider whether the guidance given in approved document B was adequate for the purposes of ensuring safety of external cladding systems?
Immediately after Garnock, probably not, because we'd concluded it didn't comply with the guidance as it stood at the time. Then the issue was looked at again following the Select Committee inquiry, I think.
Right. So my next question was, did you consider that the use of plastic products and combustible materials in the external wall build-up of a building above 18 metres required further examination?
I'm not sure I personally came to that conclusion immediately after the time.
Right. The timing is something you've just mentioned. In fact, it's right, isn't it? The fire happened in June 1999, and the Select Committee gathered in July. It started taking evidence, didn't it? Do you remember that?
I can't recall the dates, but I think it was fairly quick, yes.
Right. Now, let's look at the Select Committee. CLG 3019478. This is the report entitled Potential Risk of Fire Spread in Buildings via External Cladding Systems. And you can see that it was published on the 14th of December 1999. And as I say, note the timing. The publication of this is after the first BRE report to North Ayrshire, which we saw together in September 1999. But it's before the August BRE report, yes?
I see, yeah.
Yes, so it sits between the two. And it's important that you understand the chronology. Now, am I right in thinking that you didn't attend the evidence session to the inquiry in July 1999? You didn't give evidence?
That's right. I mean, there were people at BRE much more expert than me on this subject.
So you say, and but you didn't attend to give evidence, and I don't think you attended the session, did you?
No, I think I I was mostly left behind to answer the phones, I think, while everybody else went.
All right, and everybody else was Sarah Colwell, Tony Morris, and Peter Field.
Yes.
Now, let's go to the recommendations made in this document. First, do you remember reading this document at the time when it came out in mid-December 1999?
Yes.
You did. Let's go to page 8 and look at paragraphs 14 to 16. On that page at paragraph 14, it says this: the inquiry also prompted further research at the Fire Research Station of the Buildings Research Establishment, BRE. The conclusions arising from this research, which was carried out in 1994, support the claims of our witnesses that the small-scale tests upon which existing guidance relies are insufficient properly to evaluate the performance of complete cladding systems in a fire, and that there is therefore a clear need for full-scale testing. And note that last sentence there. And then it goes on, over the page, please, at paragraph 15. BRE proceeded to develop an appropriate full-scale fire test known as a test for assessing the fire performance of external cladding systems. And that has a footnote 25, which is the reference to the evidence. This test was submitted to the DETR in 1996. Witnesses suggested that this test would be a considerable improvement on the small-scale testing which is currently carried out to ascertain the fire performance of materials used in external cladding systems. And then 16, other witnesses suggested that this test would not be suitable for all external cladding systems, and in particular that it would not be a suitable method of testing the fire performance of infill systems, such as that which was involved in the fire at Irvine. However, we note the view of Peter Field of BRE, which developed the test, who told us, quotes, "We believe the test facility itself could be accommodated to assess the fire performance of systems which are not the same as total cladding systems and may involve windows and decorative panels. The advice we have received concurs with this opinion." And then, and I'm sorry to prolong reading this out to you, Mr. Martin, let's go on the foot of the page under conclusions. And you can see, if you scroll to the bottom, the adequacy of the regulations pertaining to their use. That's the heading. And it says this: notwithstanding, and this is in bold, notwithstanding what we have said in paragraph 18 above, we do not believe that it should take a serious fire in which many people are killed before all reasonable steps are taken towards minimising the risks. The evidence we have received strongly suggests that the small-scale tests which are currently used to determine the fire safety of external cladding systems are not fully effective in evaluating their performance in a live fire situation. As a more appropriate test for external cladding systems now exists, we see no reason why it should not be used. We believe that all external cladding systems should be required either to be entirely non-combustible or to be proven through full-scale testing not to pose an unacceptable level of risk in terms of fire spread. We therefore recommend that compliance with the standard set in the test for assessing the fire performance of external cladding systems, which has been submitted to the British Standards Institution for adoption as a British standard, be substituted in approved document B for previous requirements relating to the fire safety of external cladding systems. Now, that last recommendation in bold I've just read to you, which starts at the bottom of 9 and runs over to 10, what did you understand that to mean?
The Select Committee had taken the view that you should either have an entirely non-combustible wall construction or something that passed the full-scale test.
Yeah, and did you understand that to mean that small-scale testing for Class 0 under BS 476 Part 6 and 7 would be replaced by a full-scale test? Or should be replaced by a full-scale
Yes, that was their view.
Yes. Now, what consideration was given to that recommendation within the department so far as you were aware at the time?
I don't know all the details what went on at the department. As I say, I was acting as a contractor there, and so I did get excluded from some conversations. And all I recall it is at some point being advised that the department was taking a slightly different approach, which was retaining essentially the guidance that existed already, or providing the large-scale test. I think I can only vaguely remember exactly what happened, but it ended up being the amendments to ADB in would it be 2002?
Well, July 2000.
July 2000. Yeah, it was those amendments. I think there were some changes there. I wasn't really party to the process that came to that conclusion.
Now, that's government. Do you remember discussing these recommendations within the BRE at the time, late 1999, early 2000?
To a limited extent, yes, but I don't think I was particularly involved in those conversations either.
Right. Do you remember what the reaction within the BRE was to these recommendations I've read you? And particularly one about replacing Class 0 with a full-scale test method?
I don't remember a significant reaction one way or the other.
Do you remember, whether significant or not, do you remember whether the mood was one of agreement and adoption or resistance and disappointment?
No, I can't remember anybody expressing anything.
Right.
Either way.
Can we then go to the department's response to the committee's recommendations? That's at CLG 140347, published on the 6th of April 2000. You can't see the date, I'm afraid, from this document, but you'll have to take it from me that that is the date. In the title, it's called Government Response to the First Report of the Environmental, Transport and Regional Affairs Committee on Potential Risk of Fire Spread in Buildings via External Cladding Systems. Introduction. Further to my letter of 15th March, I'm writing in response to the conclusions and recommendations that the Environment, Transport and Regional Affairs Committee made in its first report, which was published on the 14th of December 1999. As you know, I myself gave evidence to the committee, and I'm pleased to report that we have already addressed most of the recommendations you make. Now, if we go on down, please, to page 2, paragraph 5, you'll see there that it says this: following a full public consultation on proposals for amendments, Part B of the Building Regulations and approved Document B have recently been reviewed by a working group of the Building Regulations Advisory Committee. The members of this group are all experts with a particular interest in fire safety. The review has just been completed, with amendment regulations being laid before Parliament on 21st December 1999, and the 2000 edition of the approved document being published on the 20th of January 2000. The amendment regulations and the 2000 edition of the approved document will both come into force on the 1st of July 2000. Now, first, did you have any involvement in any aspect of drafting the response, and particularly paragraph 5 of this response I've just read to you?
No.
Do you know who did?
That would have been Tony Edwards and Anthony Bird, and the building regulations team. I suspect quite a lot of people were probably involved in the drafting of it.
Right. You say the building regulations team. Who was that?
So in the division, as well as the technical specialists, there are a number of policy officials. I imagine Caroline Cousin would have still been in charge of that side of the team. She most certainly would have been heavily involved in the drafting of this.
Right. Now, you were sitting, weren't you, 2 days a week, or 2.5 days a week on average, I think, at the department at this time. You had no involvement at all in this?
I don't remember drafting it. I remember conversations about it. I think to a large extent I was excluded from it.
Why is that, given your role that you've explained to us?
I don't remember anyone telling me, but I suspect it's probably because there was an overlap between my responsibilities at BRE and the department.
I mean, did you learn that behind the scenes, behind your scenes at least, this response was being drafted?
I was aware that a response was being drafted.
Right. You weren't consulted on it at all, or weren't involved in any of the discussions about it?
Not that I remember. As I say, I think while I was certainly at this stage, when I was at the department, I was treated as an outsider to some extent, and so there were various things that I wouldn't be directly involved in.
Now, if we look at paragraph 6, it says, during the review there was no suggestion that the guidance given in the approved document was insufficient, or if followed would tend to create an unsafe scenario in a fire situation with respect to the external cladding. I mean, did you have any involvement in any aspect of the consultation referred to here, I think, as a review.
So I think they're referring to the amendments to the 2000 amendments to ADB.
Yes. Did you have?
So I think they were. That project was pretty much done and dusted. So I didn't have a lot to do with that.
Right.
I think I helped with the dissemination of the completion of that project.
Do you remember whether the Garnet Court reports, or report, is only because there's only one by this time, and that's your and Penny Morgan's September report, were filtered through to government so as to form part of the consultation, or the review as it's called, so that the revisions to Part B of the building regulations and approved document B could take into account what you had discovered at Garnet Court?
I don't know for sure. I think I doubt that our report had a direct impact on the 2000 amendments,
Right.
but they clearly, that incident and our report would have been in the minds of officials at the department when they were drafting this.
Well, you say that. Do you know that, or is that just an intelligent speculation?
It's just speculation.
Looking at the first sentence of paragraph 6, did you agree at the time, if you'd been asked in 2000, April 2000, that, quote, there was no suggestion that the guidance given in approved document was insufficient or if followed would tend to create an unsafe scenario in a fire situation with respect to external cladding?
Well, this is referring to the feedback they got from the 2000.
You're quite right.
Review.
Let me try it differently. You're quite right. It does. It says during the review there was no suggestion. But do you agree that at the time the guidance given in the approved document was in fact insufficient, or if followed would tend to create an unsafe scenario in a fire situation with respect to the external cladding?
I think at the time I probably thought the guidance was adequate.
Notwithstanding the Garnock experience?
The Garnock experience demonstrated that something that wasn't Class O would cause fire spread. So at the time I would have thought that was the key finding. It wasn't Class O, it didn't comply. So it wasn't evidence there was something wrong with the guidance.
So is it the case, therefore, that you thought at this time that the small-scale tests used to achieve Class 0 were sufficient properly to evaluate the performance of composite cladding systems in a fire?
I'm not sure if I had a view at that time, one way or the other. I would have listened to my colleagues at BRE who felt at the time that large-scale testing was a better option. But the department was obviously taking a different line in saying that it would only be a way of demonstrating compliance if you didn't meet what's become known as the linear route.
Right. It looks from this, and tell me if this is, using your memory, if this is correct, that the department did not adopt the recommendations made by the Select Committee about substituting the existing tests for non-combustibility and a full-scale test, and stuck to Class 0 because there had been a full public consultation on proposals for amendments which had already been laid before Parliament, and had been laid before Parliament only the week after the report had been published, and therefore it was too late to make the change.
That's my recollections. The department decided it didn't want to follow that recommendation. It's not unusual. Select committees often make recommendations that governments reject.
But is it the case that it didn't follow the recommendation, not because it didn't believe in it as a matter of science, but because as a matter of policy making it was too late, given the work had been done on the revised regulations and approved document B?
I think that would be conjecture on my part.
Right.
The way I'm reading this is that the department saying we've been through an exercise, and during that exercise, this wasn't brought into question, and therefore the department thinks it's okay.
Right. Is there any connection between the excisions that we've seen of the statements about Class Naught and combustibility in your and Penny Morgan's September 1999 report from the report sent to Government Anthony Bird in August 2000, on the one hand, and Government's decision to reject the Select Committee's recommendation in April 2000 on the other?
If there was any connection, I wasn't aware of it.
Do you accept that the only explanation for those excisions is that somebody was told to excise them in order to make the BRE's report to government in 2000 about Garnet Court consistent with the government's earlier decision to reject the Select Committee's recommendation?
I can't believe anyone would have said that. I just don't. Thinking of all the people involved, I can't imagine any of them would have done that.
Right. Can you think
but I don't know for sure because I wouldn't have been involved in that conversation. But I find that hard to believe.
All right. I think sitting there, though, I've asked you this before, but just one more time, if you would just humour me. Can you think of any reason why those parts of those reports would have been removed?
No, it does seem odd. I can't think of a good reason for it.
Let's move then to the 2000 edition of Approved Document B. Did you have any involvement yourself in any aspect of the revised version?
The 2000 edition?
Yes.
No, I think it had pretty much been fixed down by the time I was involved. I remember working with Mr. Bird and Mr. Edwards on developing a slide pack to set out what the main changes were and for various events that the two officials were going to.
Yeah. Now let's go ahead then in time and look at the transcript of your evidence to the coroner at the inquest into the deaths at Lacknell House, which you gave on the 13th of March 2013. It's at INQ 30157070, please, and if we can go to page 8 in that. I just want to show you this and ask you a question about it. At line 19, counsel is asking you a question. The version of the approved document B that the members of the jury have looked at up until now is the 2000 edition with 2002 amendments. Your role, as I understand it from your answer a moment ago, was to lead a team preparing the 2006 edition. Is that right? And the answer is yes. This is I should to say your transcript. Yes, I was involved to some extent with the introduction of the previous edition, although most of the policy decisions had already been made by then. So it was more about disseminating the 2000 decision, making people understand it, or helping people understand the changes that were introduced then through seminars and training programs and so on. Now, that's what you told the coroner about the 2000 amendments. My question is, to what extent were you involved in the 2000 amendments in relation to dissemination, if not drafting?
I think I may have spoken at some seminars as well. I've spoken to quite a few over the years. Once we'd agreed a slide pack, we probably would have shared the work of disseminating information. And I think as an independent consultant, as I was working for BRE at some points, I would also give talks on those changes to clients.
And what was the 2000 decision that you've referred to here? Was it the 2000 amendments, which were published in July of 2000, or was it the April 2000 decision by the government to reject the Select Committee's recommendations?
I don't remember. I don't know why the word decision's there. I need to look through the whole...
Right. Now, we know that the Select Committee's recommendation to substitute Class 0 for the full-scale test was not followed. and diagram 40 and class 0 remained in approved document B thereafter, and indeed in the 2000 version of approved document B. Yes?
Yes.
Yes. Were you ever told about why that was? I mean, did anybody ever explain to you why, despite the recommendations, diagram 40 remained unamended?
I don't remember someone directly explaining the thinking, no.
Did you ever ask?
If I did, I don't remember.
And can you help us with what was behind the reasoning? Do you know?
I'd be guessing.
All right, don't guess. Do you know who made the decision, apart from perhaps the minister, as we can see from the document I've shown you?
Decisions in government departments rarely get made by one person.
Well, do you know who joined in?
It would have been the policy lead, so that'd be Mr. Edwards, Mr. Bird, probably speaking to Mrs. Cousins, and no doubt they would have spoken to the head of division as well.
Let's go back.
It would have been in Paul Everall then, I think.
Right, I see. Let's go back to the government's response, the department's response to the committee's recommendations again. At CLG 140347. And let's go to page 9. So page 3, paragraph 9. Page 3, paragraph 9, which I read to you earlier. Now, that's the department's response to the recommendation we've looked at, namely that the full-scale test should be substituted for previous requirements. And here we see paragraph 9 explaining that the FAR Note 9 would be referred to in the forthcoming 2000 edition of the approved document, but as an alternative, right? Do you know who it was who decided or who took part in the making of the decision that FAR Note 9 could or should be referred to at all in approved document B in the forthcoming edition in July 2000?
Would be the same group of people, of various officials in the department and ultimately the minister.
Right. On what, do you know on what basis that decision was made?
Again, it's mostly conjecture, but the impression I have is that it was decided that the Select Committee's recommendation might be unreasonably onerous, and so they picked what they considered to be a more reasonable approach.
Right. Now, I mean, it sounds from your answers that you don't actually know, but you're sort of trying to fill in the blanks, doing the best you can. Is that fair?
It's very difficult when you go back that long to work out whether you remember something or whether you believe something.
Yes.
And I couldn't categorically say exactly what was being thought at that time.
You see, the reason I'm pressing you on this and trying to get a bit more out of you than perhaps you can give us is that you are the only person in the world, I think, who was both at the BRE and in the department half a week apiece. And here we have a huge piece of research done since the mid-90s by the BRE, which turns into FAR Note 9, which is in the process of becoming a British standard of great importance to the BRE, which is going to go into the regulation, went to the approved document. But we also have government rejecting a Select Committee recommendation, which has implications for life safety. And on the assumption that my description just now is correct, Mr. Martin, and I don't think you disagree with it, it's strange that you were so insulated from these goings-on.
I think you're placing me in a higher position than I was at the time. Certainly when I was working at the department, I can't think of I would use the term oily rag. I can't think of it. I was the person that did the work that nobody else wanted to do, which gave the officials more time to do the work that they were doing. I certainly remember in particular Mrs. Cousins being quite cautious around me in terms of what information she would or wouldn't share. So I think the fact that I was excluded from certain things doesn't surprise me, and might even be appropriate at some times, given that I think some people have suggested that BRE would benefit from this test being introduced in building regulations. It wouldn't surprise me if, certainly thinking back to the character, Mrs. Cousins probably thought he shouldn't be involved in that conversation, or people will think that BRE has stitched this up.
Well, that's was that a thought that crossed your mind at the time?
No.
Right. Well, then, there we are. Did you have any basis for understanding something about these decisions and the reasoning behind them in order to be able to help people understand the changes that have been made, as you told the coroner in 2013 you did?
I was helping people understand the impact of the changes to the approved document, not the policy that sat behind them.
Let's then look at paragraph 11 at the foot of this page, foot of the screen. It says, when the technical amendments to the document have been completed and it has been adopted as a British standard, the Department will amend the reference in the approved document to BRE File Note 9 to reflect its status as a British standard. We will also review whether the reference to this method of demonstrating compliance should be strengthened. It is unlikely that any such changes will be made immediately the status of the test method is changed. As such, minor amendments to the approved documents are difficult to promulgate to ensure that all users of the document are made aware of the change. However, supplements to the approved document are planned to give guidance on the new harmonised European methods of test, and the amendment would be included in this. Were you aware in 2000 that the department had stated that following the adoption of the BRE's full-scale test method as a British standard, it would review whether the reference to this method of demonstrating compliance should be strengthened, as we can see there?
I would have read this document, so arguably I was aware. It wasn't at the forefront of my mind.
Right. What did you understand it to mean when you read it?
I don't remember what I understood at the time, but
Right.
it looks like they would review the way that the standard was referred to.
Right. I mean, was it a reference to reviewing the possibility of substituting that test method for the existing requirements under diagram 40, or at least going some way towards doing so?
You could probably read that a number of different ways.
How did you read it at the time?
I don't remember.
Did you have any indication from the department or any information or discussions about reviewing the possibility of substituting the existing methods under diagram 40 and in its place putting what became 8414?
No, I think the purveying view, if you like, in the department was that this was done and dusted.
So you never heard any discussions about any such review taking place?
I don't remember one, no.
Or any discussions about why it hadn't taken place? Now, we know that no amendment was ever made to strengthen the reference, so to speak, using the expression here, to File Note 9 or BS 8414 in the supplement to the approved document when harmonisation came in 2002. That's right, isn't it?
I think so. Yeah.
Yes. Do you know why that was?
No.
And again, can we take it from your answers that you never heard any discussions, were never involved in any discussions about that prospect?
No, I think there was so much effort being focused on the introduction of the new classification system. That's where all the thinking was going.
And do you agree with me that there was no amendment to, again, so to speak, strengthen the reference to BS 8414 when it was included in the 2006 edition of Approved Document B, published in 2007?
No, I mean, essentially we transposed the reference to File Note. What was the reference to File Note 9 to the correct reference to the British standard at the time?
Yes, but there was no strengthening of the reference in the sense of bolstering its importance and making it not just an alternative, but perhaps the way of going about things as an alternative to non-combustible.
Definitely didn't do that.
No, nor in 2010, nor in 2013.
Correct.
In fact, I think it's right, isn't it, looking at the history, that throughout all of these amendments, 2000, 2002, 2006, 2010, 2013, BS 8414, as it became in 2002, was provided as an alternative to meeting the provisions of 12.6 and Diagram 40.
Yes.
And it was only in December 2018, 18 months after the Grenfell Tower fire itself, that the government did away with Class 0 and required materials which had become part of an external wall to be A2 or A1.
That's right.
Why is that?
It's quite a long history.
Exactly. And why was it? My question is, why is it such a long history? Why did it take the Grenfell Tower fire to provoke a change which had been flagged clearly by the Select Committee in 1999?
So, as I understand it, the decision was made in response to the Select Committee that there would be two options, which essentially is what the Select Committee was recommending, although it suggested a more onerous linear route, if you like. It was suggesting totally non-combustible. At that time, the department had decided to have a less onerous linear route available, or the test. And so once that decision was made, it wasn't something that we had reason to revisit.
Did you never have any insight yourself into why the department had decided to have a less onerous linear route?
I think, one of the problems with an absolute requirement for non-combustibility is you get problems, as I mentioned before, with like decorative finishes and other components of the wall, where if you adopted a near enough absolute requirement for non-combustibility, it's probably impracticable and unreasonably onerous. You'd be banning things that are perfectly safe, and so I think that's why the department came to this approach of the linear route being a combination of controls of the surface and restrictions on insulation. And we're going to talk about fillers at some point, I guess. That whole question, that was a kind of more nuanced approach to the linear route, or the alternative of the full-scale test. And as I said before, the problem with full-scale tests, they're logistically and financially challenging. They're very expensive. They're very difficult to set up, and so are going to be unpopular with industry.
Now, that rationale you've just given us, Mr. Martin, was that rationale the subject of express discussion between you and Mr. Bird at any time, or you and Mr. Harrell, indeed, at any time, between 2000 and 2013 on each and every occasion of the amendments to approved Document B?
I doubt it. A lot of the amendments that were made in between 2006 and, well, really from 2006, were driven by specific drivers. So the 2002 amendment was driven by the introduction of the European tests. So the UK government had no choice but to introduce these provisions, and that was a huge task.
Well, just forgive me. If you'd done away with Diagram 40, you wouldn't have to worry about Class B, would you? If you'd done away with 12.6 and only had...
If approved Document B only covered external wall construction, you're right, but it doesn't. It covers a wide range of different things. So the drivers were quite specific and quite narrow, and so the terms of reference of those changes were very limited. So that's why that question wouldn't have arisen in those pieces of work.
Now, you described yourself in 2000 as an oily rag, doing the jobs that other people wouldn't do. Whether that's just modesty or whether that's true will remain to be seen, Mr. Martin. But did there ever come a time when you asked Anthony Bird, why did the Select Committee's recommendation get rejected by government? And why are we not strengthening the reference to 8414? Did you ever actually ask him that question?
I don't think I ever did, no.
Why is that? Given your responsibility as it came later in the amendments from 2006 onwards.
I think we just considered it as water under the bridge. It sounds really glib, and I'm sorry, but that's it, those were decisions that had been made, and so unless there was a driver to revisit them, it didn't come up.
Would not the driver to revisit them be the occasion of the amendments?
No, because those amendments had very limited terms of reference.
Well, and we'll come to 2006, for which the contract was put in place in 2004, and we'll come to that later,
yeah.
Probably not today. But was that not the occasion to revisit the Select Committee's recommendation? Think about it again in the light of recent events. Think about strengthening the reference, go out to consultation on it, and actually come to a landing.
So for the 2002 amendments, there was a specific
I understand that.
and very narrow terms of reference, which was to take the European classifications and insert them into the approved document in the appropriate place, and avoid market distortion. That's the approach that had been agreed with,
Yes.
I guess, with ministers at the time.
Yes, and what I'm really asking you, coming back to the question, why was it water under the bridge after 2000, given that there were at least 3, if not 4, opportunities to go out to consultation on this very point, the point of the recommendation made by the Select Committee, and actually ask industry and other stakeholders, and, if thought fit, amend to reflect it?
I suppose there's no reason to pick on that subject particularly. Approved Document B covers an enormous range of different issues. So it would seem odd to just pick up on one.
No, well, let me see if I can disagree with you politely on that. We read the part of the Select Committee's report which said that it shouldn't take people being killed to bring about change. This was about life safety. Was that, and not all of Approved Document B is about life safety necessarily?
Yes, it is, absolutely.
Well, in which case, if that is the case, then why wasn't this precisely the occasion to take on board this aspect of life safety within this aspect of Approved Document B, re-examine what the Select Committee had said, re-examine the evidence which had formed the basis for it, and consider putting an end to this long history of retaining Class 0 and get rid of it?
I think you're still looking at Approved Document B with a very narrow lens. It's all of those issues. I'm sure someone would argue that many of the others are equally as important. Clearly, to this inquiry, it's quite right that you're asking questions about external wall construction. But at that time, that's just one of numerous subjects. And the task that the people working on that 2002 amendment was take all these new classifications, insert them into the existing provisions without any fundamental change to the net result, if you like, so that there'd be no market distortion.
At what stage over the years between 2000 and 2018 did you conclude that the Select Committee's recommendation was, as you put it, water under the bridge, would never be followed, and that the BS 8414 full-scale test series would never replace the provisions in Diagram 40 of Approved Document B?
I don't think I ever concluded it would never happen.
Well, when would it?
It would be at the next opportunity for a full review of that subject matter.
2005.
So the 2005 to to what resulted in the 2006 review
I see.
would have been an opportunity.
You say it would have been. Why wasn't it?
We certainly made some changes to the guidance,
Right.
and
I see. So
made it more onerous, but we didn't go to the point of. There wasn't a reason at that time that emerged in that process to replace diagram 40 and that specific piece of guidance.
well, we'll come to that moment in the history when we come to it. I'm going to leave this line of questions for the moment, but can we leave it on this basis that that was the next opportunity to the 2006 amendments? That was the next opportunity to ask the question: when are we going to adopt the Select Committee's recommendations, or are we going to adopt the Select Committee's recommendations? And if we're not, why are we not? Was that amendment the next milestone on the road?
I guess so, yes.
Right. Mr. Chairman, I'm going to turn to a different topic, radar.
Yes.
This is slightly early and therefore out of character, but we should probably have a break now.
All right. Well, it is a little early to take the afternoon break, Mr. Martin, but I think we'll take it now because it's a practical convenience to do that. We'll stop now and we'll resume, please, at 3:30. And as before, please don't discuss your evidence with anyone outside the room.
Yes, sir.
All right. Thank you very much. Thank you, Mr. Millett. 3:30, please. Would you ask Mr. Martin to come back in, please? Right, Mr. Martin, ready to carry on?
Yes, sir.
Thank you very much. Yes, Mr. Millett?
Thank you, Mr. Chairman. Mr. Martin, we're now going to move to some questions about the radar projects, and we're going to look at the period from about the beginning of 2001 onwards and your involvement in that work, which followed on from those projects. Now, first, were you aware of the radar projects at the time?
Yes.
You were. And it's right to think that the radar research project was initiated in order to help the department understand how the new European methods and classification systems could be or should be implemented into the UK system and guidance, yes?
The English system, yes.
Yes, the English system, very well. And the research was commissioned by the department, wasn't it?
Yes.
Carried out by Warrington Fire and done in 2000.
Yes, I think it was a Partners in Innovation contract, so it would have been part funded by industry.
Indeed. And if you go, please, to CLG 401068, we can see the Radar 2 research. Just look at that with me. That's a joint working party, BRAC working party, 28th of February 2001 minute. And if you look at paragraph 4 in that, you can see that it's considering reaction to fire as well as resistance to fire, isn't it? Radar 1 was fire resistance, Radar 2 was reaction to fire.
Yes.
Were you aware of this research at the time it was carried out?
Yes, I think I was. Probably at the tail end of it, I think.
Right. Now, the products of that research on reaction to fire were contained in 2 reports in May 2000. We have those at CLG 50950 and 951, respectively. We'll look at the second of those, but were you familiar with those at the time? As I say, May 2000 is when they were dated.
Yes, I would have been, yeah.
Right. Let's look at the second of those then. CLG 50951. There it is there. It's entitled Radar 2 Project, Correlation of UK Reaction to Fire Classes for Building Products with Euroclasses and Guidance on Revision of Approved Document B, Part 2 Proposals for the European Supplement to Approved Document B. And if you look at the bottom right-hand side of the screen, you can see that it's dated the 26th of May 2000. Do you think you saw that document at the time?
It seems likely.
And would you have seen it when sitting in Garston or when sitting in Eland House?
Possibly both.
Right. Yes, they're not mutually exclusive. I see that. Were you involved in the project at all, either from the BRE or from the government side?
No.
No. If we go to page 6 and table 6 at the top of the page, let's just run through this together. You can see that here is a table of possible options for transposition of classes for reaction to fire performance. Are you familiar with this table? Or were you familiar with it, do you think?
Yes.
Yes, and you can see on it that the proposal there was to equate Class 0 with Class B or better, Euroclass.
Yes.
And if you look at page 8, please, you can see at the very top of the page under little c, as follows. Any reference to Class 0 being equivalent to Euroclass A2 would severely restrict the market choice in terms of materials for specifiers and clients. This applies to virtually all organic containing materials. In Germany and France, the authorities have a single classification, i.e. B1 or M1. Thus, Euroclass B could be a cross-border compromise, which is supported by the high product density obtained at the Class 0 to Euroclass B transposition point. We've covered a lot of this with earlier witnesses, but just looking at the first part of that paragraph, any reference to Class 0 being equivalent to Euroclass A2 would severely restrict the market choice. From what you knew at the time, both sitting in government and at BRE, is that correct? That there was a fear of market restriction if Class 0 was to be equivalent to Class A2?
I don't remember it in those terms. I know that the objective of the work that the department had set out on was very much based on this concept of avoiding market distortion. I've used that phrase several times because it was the kind of go-to phrase throughout the whole project. In that what the department didn't want to happen was, in the process of introducing these new tests, you'd find large swathes of products that used to be allowed suddenly not being allowed, or potentially vice versa.
Yes. And that was for market distortion reasons rather than fire safety reasons, if I can put those two concepts broadly. Is that right?
Yes, I think so. I think that was the
Yeah.
the intention was to try and deliver the change whilst avoiding market distortion, and I guess alongside that would be not undermining fire safety.
Do you agree that only very few products achieving Class 0 would be capable of achieving Euroclass A2?
It would seem likely if you were declaring Class 0, that's because you couldn't claim material of limited combustibility. So I guess it follows that they would probably align.
Is that right? I thought one of the ways you could claim Class 0 was that you had a material of limited combustibility.
In general, a manufacturer is going to claim, is the thing they're going to put in their literature is the best classification they've got. Somebody with Class 0 could say my material is Class 1 if they wanted to, but it would be a strange thing to do from a marketing point of view because it's actually Class 0. So I think that's the point here, is that if somebody's declaring Class 0, it's because they probably can't declare material of limited combustibility.
Right. But that, in fact, and we'll come to this later on, but just to come straight to the point, that was always the case, wasn't it?
Yes.
Diagram 40 never required limited combustibility.
That's right.
Do you think that any reference, or did you think, when you saw this at the time, that any reference to Class 0 being equivalent to Euroclass A2 would have been very likely to have met with resistance from the industry?
I don't think I was that involved to have come to that conclusion.
Right. Would it not mean, though, that at the end of any equivalence period, or any transposition period, an equivalence between Class 0 on the one hand and A2 on the other would mean that buildings over 18 metres would be clad in materials which performed better in a fire?
My understanding of reaction to fire tests and the conversations I've had with fire scientists about reaction to fire tests is it's very difficult to compare one with the other. And so there may be situations where a Class B product is not as good as a Class O product. I can't think of one. I don't have the data, but I think in general the Euro classes were considered to be certainly the Euroclass B test was considered generally to be a bit better than the BS476 or Class O status, but the conclusion that the department had come to through this process was that the most appropriate transposition between the two, or the correlation between those two systems, was that B would correlate with Class O.
And the driver for that was that it would let more products through above 18 metres, whereas if you picked A2, it would let fewer products through above 18 metres. No?
That strikes me as an odd way of saying it. What they were trying to do was find the best fit between the new classification system and the old classification system, and they concluded the best fit was the one that they adopted.
Right. I mean, were you involved in any of these discussions about the transposition points or transition periods?
At that time, not particularly. I was pretty much handed a schedule that said this is how the different classification systems would correlate.
And when was that? When were you handed this schedule?
in the process of the work we did on the 2002 amendments. I think so at some point or other it was this is where the department and its partners have arrived at what they consider to be the best fit between the two systems.
Right. Can we then go to page 9 in this document and look under the heading, paragraph 4.5, cellular plastics sector? And it says there under B, if you look at paragraph B, products 4/05 and 4/12, which also give class 0 on the UK system, give respectively Euroclasses C and D in the European assessment. Both of these products have relatively thin aluminium foil-faced flexible foam laminates, respectively based on the polyisocyanurate and phenolic foam. With these products, it was observed that in the SBI test, the aluminium foil facing was penetrated, such that the underlying foam was then available to contribute to the rate of heat release calculation, whereas in the UKBS 476 Part 6 test, the heat release found in that test was not sufficient to displace the classification away from a UK Class 0. Clearly, the introduction of a simple replacement of the UK Class 0 by a Euroclass B requirement in any regulatory procedure would discriminate against products 4.05 and 4/12 against the practical experience of their acceptability in the UK market for Class 0 applications. Now, that's a long paragraph, but just simplifying it, it looks, would you agree with me, that Warrington had come to the conclusion that some cellular plastic composite products achieve Class 0, but not Class B, because although the heat release rate satisfied Part 6, it didn't meet the figure levels required in the SBI test to meet Class B, but only Class C or D.
Yes.
Yes. But, isn't it right, that requiring those products now to meet Class B would effectively limit their market and discriminate against them in that way?
Yes, that's what that says.
Yes. Did you consider that to be a concern for any reason?
That wasn't really on my agenda at the time, but I imagine that would be a topic of debate amongst the people that were working on this.
I mean, does it tell us that these products would become unacceptable where previously they had been widely accepted because they had achieved Class 0?
If they were being used in a location where Class 0 was the only requirement, then yes.
Yes. Well, whether they were or weren't, if you're looking at equivalence or some sort of matching, transposition being the word I think used here, it's right, I think, that those products, tell me if this is right or wrong, would become unacceptable where previously they had been widely accepted on the basis that they had Class 0.
Yes, I think that was my understanding. That was something that was that was given quite a lot of debate at the time.
Did you yourself consider that it was important to avoid discriminating against foil-faced PIR or phenolic foam, polymer foam insulation products, regardless of their comparatively poor reaction to fire performance when assessed against the Euroclass system?
I don't think I had an opinion at the time.
I mean, cutting to the point, what was wrong with discriminating against a lower standard of fire safety in order to achieve higher standards of fire safety?
Well, there's nothing wrong with that if that's what you're setting out to do.
Right. There's nothing wrong with that if that's what you're setting out to do. But if you're setting out to avoid market distortion, why wasn't it important nonetheless to maintain or promote standards of fire safety?
Well, I wouldn't have had an opinion at the time, but I think what the department was trying to achieve at the time was this like painless transposition into the new classification regime, and what this report is identifying is a potential pain.
Well, you may have to accept pain one way or the other.
Absolutely.
And I think the thrust of Mr. Millett's question is, why isn't it more acceptable to accept a bit of pain on marketing certain products and gain on the fire safety? But that, you would say, is a policy decision.
Yes.
And what did you understand the basis for that policy decision to be?
Well, the policy decision was to transpose B to O. So where O was the only requirement, B would be.
Were you involved in any of these discussions about equivalence, market distortion, fire safety, balancing the two at the time, either within the BRE or within the department?
I think I got the general gist from colleagues that were involved, but I wasn't directly involved in those decisions.
Now let's go to approved document B, which incorporated these amendments in 2002. That's at CLG 140740. I want the first page of that, please, to show you what we're looking at. And you can see from the green triangle on the bottom right that it says 2000 edition consolidated with 2000 and 2002 amendments. And if we go, please, to page 91, we can see the change. Here we have diagram 40, heading provisions for external surfaces of walls, and we can see now for the first time there are 3 boxes, and the second one has class 0, national class, or class B, S3, D2 or better, European class. Yes?
Yes.
Yes. Now, that's the section which would apply to the external surfaces of buildings with a habitable story over 18 metres, isn't it?
Yes.
Yes. Now, if you look at the small print at the bottom under the word notes, you can see that there is a paragraph under 1 that says this: the national classifications do not automatically equate with the equivalent European classifications. Therefore, products cannot typically assume a European class unless they have been tested accordingly. Were you involved in the drafting or the discussions about the drafting of that note?
My recollection is I was given that text. I'm pretty sure one of the tasks I was given when I was probably working for the, would have been while I was working at the department in that sort of secondment role, was to go through the draft and insert that text in all the appropriate places. But I wasn't involved in the drafting of that particular paragraph.
Go through the draft and insert what?
So there's a draft approved document which needs to go off to the typesetters, and I worked my way through the draft, that draft that was going to go to the typesetters, and found wherever there was a reference to the Euro classes and inserted that note. That was the instruction I was given. So that's what I did.
This note appears elsewhere, does it?
All over the place, yes.
So, tell me, so you received this note as already finalised?
Yes.
Right. Did you have any discussions with anybody about what it meant?
I think I had it explained to me, yes.
How was it explained to you?
There was a concern that a manufacturer that had a classification under one system might think they could reasonably claim that that was the same. So somebody who had a Class O product could advertise their product as a Class B product, or a non-combustible product, claim it as being a Class A1 product. And what this was trying to say was the manufacturer should only declare the classifications that they have specific evidence for, even though the approved document may treat them equally in the guidance.
First of all, who handed you the text to insert in here and other places in approved document B for the 2000?
Would have been one of the officials in the department, so Anthony Bird, or was Tony Edwards still there? Can't remember. But it would have been an official in the department.
And who gave you the explanation you just given to us?
It was probably Anthony Bird.
Right. Did you discuss the drafting? Did you look at it together and assess it?
I think it was one of those points where this had been debated at length, and it wasn't something that I particularly wanted to discuss again, I think.
At all events, I think you've told us that you provided no input into the wording at all.
That's
you
right.
were given a fait accompli, effectively.
Yes.
Yes? Yes. It's right to think, just looking at it, that there's no equation at all, automatic or otherwise, between Class 0 and Class B.
That's right, yeah.
Yeah. When you looked at this, did you think that this form of words here might introduce confusion, because some people might think that there was an achievable equation, which is the word that's used there, between Class 0 and Class B, albeit perhaps not automatic?
I suspect I probably had it explained to me at the same time I was given the text, and so that was in the forefront of my mind when I was reading it.
Right.
I imagine, which I'm sure is what's happened with your good selves, is you've read that without having someone explaining it first, and I've heard you ask this question of other witnesses, and I agree it's unnecessarily complicated language.
Yes. I mean, did you think at the time that some people might take from this note that Euroclass B was, quotes, equivalent to Class 0?
Very difficult to separate out what I was thinking with what I was told.
I mean, it's not, is it, though? I mean, as a matter of fact and science, Class 0 and Class B are not equivalents.
No, they measure different things, similar things, but in different ways.
Yes, and they're not equivalents.
Correct.
Now, given, as you just told us, that they measure different things in different ways, the test methods, the setups, the measurements are, under each regime are different, extensively so, I would suggest to you, with only certain areas of overlap. Do you know why that fact was not spelt out here in clear terms?
No, I mean, you wouldn't have put it here. If you'd have put an explanation of that anywhere, you might have put it in Appendix A. But I don't think it does that in Appendix A very well either.
I don't think it does it at all in Appendix A, with respect. Do you know why no clear warning was given, either within Diagram 40 or within 12.6 or within Appendix A or anywhere else, that to be Class B it had to be tested under EN 13501 and actually get a Class B? And also that they do not equate at all. It doesn't equate at all with Class 0. Do you know why that wasn't spelt out in terms?
No,
Was that an option even discussed at the time?
not with me.
Now let's go to CLG 100042229. This is an email some years later, 2009. And it starts at the bottom of page 1, and I'm afraid the print is quite small, so tell me if you're having trouble reading it.
I can see it.
Thank you. And if we look at that email, it's an email to Anthony Bird from Chun Jin Cho, 7th of December 2009, subject BS 476 and EN 13501. And it says, Dear Sir or Madam, I am Mr. Cho from the Fire Safety and Shelter Department, Singapore. Can I seek your assistance to clarify the equivalent standards of EN 13501 and BS 476? If you are not the officer concerned to answer my queries, I'd appreciate very much if you could direct the question it's jumped, I'm afraid, to the relevant safety officer. Thank you. Now, if we go to page 2, currently Singapore is adopting BS 476 Part 411 and Part 6 and 7 to check the non-combustibility and flame spread properties of material respectively. There were many inquiries from suppliers on the use of EN standards instead of BS for the relevant test. We've checked the relevant information from the website and found there were many write-up mentioning the equivalency of EN and BS standard as follow. And then you've got two lists. You've got the Euroclass and the Euroclass. Non-combustible A1, limited combustibility A2 or better, naught, B or better, etc. And then if you look at 3, he says, while we go through document B, there is mention of Euroclass A1 and A2 considered as non-combustible and limited combustibility, respectively, but there is no mention in document B that Euroclass B is equivalent to Class 0, BS 476 Parts 6 and 7, and Euroclass C is equivalent to Class 1 and 2. 4, may I seek your good self to clarify whether it is a regulation or mentioned in document B that the following are equivalent. And then he sets out again the UK class and the Euro class. 0, B2 or better, B or better. And then 1 or 2, C or better, etc. And then at 5 he says, thank you very much for your assistance in this matter. Best regards. And as you can see, Cho Chun Chin is from the Fire Safety and Shelter Department of the Singapore Civil Defence Force. Now, if we scroll up to the next email in the chain to page 1, we can see that a few hours later, Anthony Bird forwards this to you and Debbie Smith. You see that?
Yes.
Can you kindly assist, please? Tar Ant is what he asks. Why did Anthony Bird forward this email to you?
Because that was part of my role, was to deal with that kind of inquiry.
Right, I see. Now, by this time, of course, you were fully in the department, weren't you?
Of course, yes.
Yes. And what was Debbie Smith's involvement? Why was he sending her this request?
I'm not sure if there was a specific contract by which that would have applied at that time. I think he was sending it to her because she had a lot of expertise in this subject area, and he was hoping she might contribute.
Right. So this was an informal request for informal assistance from an expert whom he knew well.
I'm guessing so.
Right.
Dr. Smith was chair of an important European standards committee as well, so she was the national expert on this subject, I would say.
Right. Now let's go up to the top email in the chain. We can see that on the 22nd of December 2009, Dr. Smith sends you, and you alone, a response. Brian, please see a draft response as discussed. Happy Christmas, Debbie. Now, she says, as discussed. Can you remember what your discussion was about?
No.
No, nor does Dr. Smith. Did you discuss, do you remember discussing possibly the possibility of abolishing the national class system?
I doubt it.
Did the subject of the Select Committee's recommendations, by now 9 years old or so, come up? 10 years old, come up?
No, I can't imagine why it would.
Right. Were you concerned at all by the fact that in 2009, some 6 years after the 2002 edition of ADB had come into force, after the harmonisation project, you were being asked questions of this nature?
No, it seems a perfectly reasonable question to me.
Well, it's a perfectly reasonable question, but that's not the question. It's a reasonable question. The question is, were you not concerned by the fact it was being asked at this stage?
No, I can't see why I would be concerned.
Well, because there'd been an exercise in harmonisation with diagram 40, with note 1 attached to it, which said what it said. Did the fact that this question was being asked not prompt you to wonder why it was being asked at this time, 6 years on?
I think, again, you're focusing on one part of approved document B. This is a query from a regulator in Singapore, probably looking at the entire classification system, which is used throughout the Singapore regulations and guidance in the same way as it's used throughout approved document B. And certainly, I'm pretty sure Singapore was one of those countries which had been using BS 476 for as long as the UK had, and wasn't subject to the European directive. But would have progressively had more and more manufacturers saying, we want to sell our product in your country, we've classified it to the European system, how does it fit? So they were they were looking at the same question then that we were looking at in 2002.
Yes, but he's, as he says in paragraph 3, he's been going through approved document B, and as a result of his trawl through document B, he was moved to ask these questions. And my question is, when he asked these questions, did you not think to yourself, gosh, I wonder whether ADB in this respect is as clear as it might be?
No, I think the point here is that what there wasn't in the approved document was a transposition table. There wasn't the table that says that the table that you showed in the radar report, which showed A1 is equal to non-combustible, whatever it was. There's a table and it equates. There wasn't a table like that in approved document B, because what we'd done is we'd inserted the European classifications as necessary throughout the approved document. So there wasn't a summary table that provided a comparison between the two classification systems. And so I think what the official from Singapore is asking is, have I read this right? Is this how you've compared the two?
Well, that's the point. And did the fact that he asked the question not prompt concerns in yourself and Anthony Bird and perhaps Debbie Smith too, that ADB, because it did not clearly identify the transpositions, was not as clear as it could have been?
No, I'm sure I'd have the same problem if I read the regulations in Singapore.
Well, I'm not asking you about the regulations in Singapore. My question is a very simple one. You're getting a question here about the clarity of transposition in a proof document B, which is by now 6 years after the transposition harmonisation exercise. My question is, when you were asked this question, were you not prompted to ask yourselves, is this document as clear as it could have been?
No.
Why is that?
That was the answer I was trying to give you earlier on. I think it just struck me as a perfectly reasonable question. An official in Singapore is developing their own equivalent transposition table. They've looked through approved document B. They've looked at it and identified what they think is the transposition approach that we've adopted, and they want to double check they got it right.
Perhaps you misunderstood.
Which they had.
It must be my fault for not asking the question properly. Let me try it slightly.
Well, I think the question Mr. Minnitt's asking you to address is, did it trouble you to think that Mr. Tune couldn't work it out for himself?
I think he had worked it out for himself.
Why was he asking the question then?
Because he was about to introduce changes to legislation in Singapore and wanted to double check that he hadn't made a mistake.
Right.
Let's look at the response that gets sent by Dr. Smith. CLG 1004230, please. Now, this is the document that's referred to. It's attached to Debbie Smith's 22nd of December 2009 email. And it says this: Dear Mr. Cho, re BS 476 and EN 13501. Thank you for your email regarding BS 476 and EN 13501 Part 1. There's no regulation that gives equivalency between BS 476 and EN 13501 Part 1. The only way that a manufacturer can declare a performance class for reaction to fire or fire resistance for their product is based upon test evidence. Therefore, 1. A BS 476 test result can only be used to derive a BS 476 class, such as class 0, 1, 2, or 3. 2. A BSEN 13501 Part 1 classification, A1, A2, B, C, D, E, can only be derived from test data in accordance with the appropriate EN test methods, i.e. EN 1716, 1182, 13823, and 11925 Part 2. For example, a manufacturer can only claim class 0 if they have tested their product to BS 476 Part 6 and 7 and met the class 0 requirements. They cannot then claim a European class B for their product without having tested it to EN 13823 and EN 11925 Part 2 and achieve the specified criteria for Class B. And then she goes on. C. The concept of equivalency relates to the guidance that is provided in approved document B, Fire Safety to the Building Regulations 2000 ADB. ADB provides guidance on classes of reaction to fire, fire resistance, and external fire exposure of roofs performance that satisfy the requirements of the building regulations. Under the Construction Products Directive European legislation, the UK must accept products that have been classified in accordance with the EN 13501 series of standards onto the UK market. Therefore, for each specified BS 476 class in ADB, a European class is defined that is also considered to satisfy the requirements of the building regulations. This approach has also been adopted in relation to non-combustibility, A1, and materials of limited combustibility, A2. I hope this is clear. If you need further information, please contact me. Now, first, do you remember whether your response to Mr. Cho was ever sent? We have no record of it going, but do you remember?
I don't remember it at all.
In the light of the email, did you consider that ADB needed to be amended to make it clear that there was no equivalence between European and national classes?
No, it didn't occur to me.
It didn't occur to you even though you'd seen this attachment?
No, I think Dr. Smith has obviously drafted a very complete reply, probably because it's from an official from another nation, so we're endeavouring to be helpful. And I think she's picking up on that point of depends how you read the word equivalence, I guess, in that the two tests aren't technically equivalent, but they're used in an equivalent way in the approved document. So it probably depends on how you approach the question of the word equivalent. And I think that the official from Singapore is probably not writing in there as English as their first language.
Well, you're not the first person to say that, but nonetheless, the question that he asked you was sufficiently clear. There was nothing difficult about the way he phrased it.
You can understand what he's saying. Yeah,
Perfectly well.
Yes.
Did you discuss this question and answer either within the department or within DRE, with Dr. Smith perhaps at the time?
Well, the email suggests that we may have had a conversation. I don't remember it. This is a fairly routine exchange.
Is it? Was this the kind of question you were getting from other parts of the industry at the time?
Not on this particular subject, but it's an email from somebody that's queer. It's unusual that it comes from an official in another country. That's not quite so common. But from time to time, you'd be contacted by people asking questions, and you'd endeavour to point them in the right direction.
You say it's a fairly routine exchange. Just to understand that, routine in what sense?
There's nothing about it that would make me want to raise it with someone else.
No. Okay, let's break that down. Routine. Would you routinely get questions from third parties, stakeholders, other regulators, industry, about the meaning or intention behind the approved document?
Yes.
Would you would? And would you routinely pass those to Dr. Smith to assist you to answer?
No.
So you passing it on to her wasn't, or Aunt Bird passing it on to her wasn't routine?
No, I think he passed it on to her because this is her area of expertise.
Right. So was it? Can we take it that it was the department's view that this was sufficiently technical and complex a matter to require an expert response, rather than a response from government saying it's all perfectly obvious, just read the document?
I don't remember the exchange. I think it may well be that he referred it to Dr. Smith because it was an official from another country,
right,
and just wanted a more complete answer. And as I say, Dr. Smith was probably the country's leading expert on this subject matter at the time.
Well, exactly. That really leads to the next question. Given the question had come from a foreign regulator, and the department had thought it fit to pass to the country's leading expert on this question, and the result is a highly technical and quite complex response. This was very far from routine, wasn't it?
It wasn't so unusual that it made us think there's a problem somewhere. We'd get questions from all manner of people.
Well, you get questions from all manner of people about all kinds of things. That I understand. But was this question not a flag to the department that there was something wrong with the approved document B that couldn't be understood and required a technical answer to?
No, I don't think so.
Why is that?
I was just struggling to understand why it would.
Because I'll tell you why it would. Because some people might be confused about whether Class 0 equaled Class B and vice versa. And if they saw Class 0, they thought it's Class B, and if they saw Class B, they thought it was Class 0.
I don't necessarily read that from the email from the official in Singapore.
Leaving aside the email for the moment, was it your wider experience by this time, 2009, that there was confusion about the equivalence or apparent equivalence on the face of approved document B between Class 0 and Class B across the UK construction industry at the very least?
Never had that raised with me at all. I think people understood that there was a parallel system and you could use either classification depending on how the particular product had been classified.
Right, well, it might have been crystal clear to you, but you say it had never been raised with you. But why was Debbie Smith clarifying what is meant by equivalency or equivalence in this email if it was so clear from the document as you understood it at the time?
My guess is she's jumping on the fact that the official from Singapore has used the word equivalence, and she's trying to make it crystal clear that there's a difference between equivalence of the test and classification and equivalence in the way it's used in approved document B.
Right. Were you aware at any time of manufacturers simply stating an equivalence between Class 0 and Class B without carrying out the European testing required?
No.
Not at all. Was that something you looked into following Mr. Cho's email?
No.
Why not?
Not something, it didn't occur to me at the time, and so it's not an issue that's ever arisen as far as I'm aware.
But it arose then, and here is the response. Did this not trigger in you, by now an official in the department, that you needed to make sure that people understood diagram 40 and the note in it in the way in which Debbie Smith is spelling out here in response to a foreign regulator's question, just to make absolutely sure that diagram 40 was understood by everybody who would claim the use of it?
No, I don't see. I mean, so the note one, albeit written in perhaps, in hindsight, unnecessarily complicated language, says the same thing, and I don't think and never come across this as being an issue, and I'm sure somebody would have raised it if it was.
Right. Let's turn then to a different topic, moving on in time, 2001, and the contract CC 1924, the review of fire performance of external cladding systems, and the revision of BR 135. Now, let's embark on this topic. We won't finish it today, I should just tell you, but let's start it. We know that there was a contract put in place for the review of BR 135 between the department and the BRE, for which the BRE bid in late 1999, after the fire at Garnet Court and after the Select Committee inquiry. I've just said that you can confirm that, I think.
Yes.
Yes. Now, that became the review of fire performance of external cladding systems and the revision of BR 135, otherwise known as contract CC 1924. Remember that?
Yes, I don't remember the contract number, but
No,
yeah.
No, all right. But do you remember that the result came as a result of the Select Committee inquiry into external fire spread?
Yes.
Yes. And by way of context, and in very brief terms, let me give you a summary and see if you can confirm that it's accurate. The BRE's work under that contract had a number of heads. First, a literature review, yes?
Yes.
Yes. The preparation and sending out of survey questionnaires, yes?
Yes.
The analysis of the results of that survey, yes?
Yes.
Yes. An experimental testing program, yes, and a review of revisions to BR 135, which had first been published in 1988 and was now up for review.
Yes.
Yeah. And what was your role in general in that project?
So the project was led by Dr. Colwell, and I was one of the number of people that worked with her to try and deliver various aspects of that work. My main focus was assisting in the drafting of the new BR 135, and I think I did some of the work on the literature review.
Right. And she told us that your specific role included, I think, as well, reviewing the guidance in approved document B, including the guidance relevant to surface spread of flame, and hence what was included in the BRE revision. Is that fair?
I summarised it, I think. I mean, I didn't review it to see whether I thought approved document B was correct or not. I
Right.
was interpreting it and summarising it in the various documents.
I see. At what stage did you become involved in the project?
I guess from its inception. I think most of my contribution was probably towards the end in terms of the drafting of BR 135.
Did you have any involvement in preparing the bids for the contract?
Don't think so.
Let's look at the signed bid contract at BRE 3041833. This is the first page of the bid contract, and as you can see, it's dated the 11th of November 1999. So this is actually about a month before the Select Committee's report was published on the 14th of December that year. And in fact, it looks as if there were two revised versions of that document after that date. And I'd like to go to BRE 3041836, please, which is the last one, the latest version in time. It's revision 2. And it's dated the 23rd of December 1999, so that's after the Select Committee's report. Are you able to help us whether this was the final version? It's unsigned, but are you able to help us whether this is the last one?
I couldn't tell you.
Right. Were you involved in drafting or revising these bid documents?
If I was, I don't remember.
Now let's stick with this revision. If we go to page 1, you can see that the title is the framework agreement. It's under the framework agreement, and that the project lead was Sarah Colwell. Yes?
Yes.
And if we go to page 9 in it, we can see under the heading project team that she's listed there at the top as the project manager and leader of all tasks. Yes?
Yes.
Yeah, and underneath that, 4 names down, we can see your name listed as being responsible for the survey, building control, and BR135 redrafting. Yes?
That's what it says, yes.
It's what it says. Now, and that's, showing you that to remind you. We'll come back to this, but in broad terms, are those the aspects of the project which you did go to work, you did go on to work on?
Yes.
So did your role change at all during the project? Did it develop?
Not that I recall.
And were you involved in the project throughout its life?
In components of it. I mean, it was as you said, a project with several components in it, and I wasn't directly involved in all of those components.
No, clearly, can I assume that you weren't involved in the Part F review, ventilation? But so far as external fire spread is concerned, and all the work leading to BR135, you were involved continuously. Is that right?
I'm kind of going to have to be pedantic and say I don't think I had much to do with the fire testing.
Right. Well, we'll come to that. But were you involved throughout in the area attributed to you here for survey, building control, and BR135 redraft?
Yes. It wasn't a continuous activity though. It was something that you dipped into from time to time as the project went on.
Now, during your time on this project, did you meet or discuss the project with Anthony Bird?
I don't know if I attended a formal meeting with Anthony, but I would have been working with Anthony from time to time, so no doubt we would have discussed it.
Yes, you were sitting half the week in his office, so yes. Now, if we go to page 12 of the document, please, you can see around the middle of the page, under the heading Project Responsibilities, it says, just under the 2 bullet points, all activity on the project shall be subject to the supervision and quality control of Dr. D.A. Smith. Yes?
Yes.
Was it in fact the case that Dr. Smith supervised all of the activity on this project, as things turned out?
As far as I remember, yes.
And in what way did Debbie Smith supervise and carry out quality control on your work?
She would have read any draft documents and commented on them, I imagine. My recollection is she's very thorough when it came to checking draft documents.
Did she check against any external materials, or did she just check within the 4 corners of the drafts you gave her?
I don't know.
But did you provide her with any core materials or external materials referred to in the reports you gave her, or did you just give her the report in draft?
I don't remember, but probably just the report.
If we go back to, how regularly did you discuss your work on this project with Debbie Smith? In meetings or on the telephone?
I doubt I would have discussed it with Dr. Smith very often. I probably wouldn't mainly been talking to, I don't think she was a doctor then, Sarah Colwell.
If we go to page 3 of the bid document, we don't need to go through it all, but the objectives are there set out. And if you look at the foot of the page, project objectives, you can see they are threefold, 3 bullet points there. To review the guidance within the approved documents, to update and maintain the building regulations and associated guidance, and to support the process of regulation and harmonisation. And then underneath that, you've got specific objectives of the department, which run over to page 4. And the first one, to carry out a survey of existing multi-storey building stock. The second is to produce a simple database of the results of the survey within 3 months. The third is to review and update the existing guidance given in BR 135. And if you go to the top of page 4 to give additional guidance on fire stopping, and then first bullet point on page 4 to complete an experimental programme, and to the second to utilise the large-scale scenario-based test to determine the most appropriate method for specifying the fire performance requirements of cladding systems. Now, was it I've just shown you some of those, but was it your understanding that all of those objectives, which are listed in the bid document, remained in place and unchanged throughout the life of the project?
Yeah, as far as I'm aware. Yeah.
And that this project was I think, an IA, well, as part of the project, an IAG was established, wasn't it? An industry advisory group.
Yes.
And do you remember who decided that an IAG should be established?
That's the sort of thing I'd expect the department to require. It's pretty standard practice in almost all research work to involve an advisory group in some. They get called different things as time moves on, but the department's always taken the approach that it's better to involve industry and other stakeholders as you develop a piece of research.
When you say the department, who? Who at the department decided that there needed to be an IAG?
Whoever the policy lead would have been.
Who was that?
Probably Anthony Bird at that time,
Right.
I think. It might have been Tony Edwards.
And what was its purpose, so far as you understood it?
I guess they have a sort of multiple functions, but really it's to challenge what the project is doing. So the worst thing that can happen from the point of view of a project managing a piece of research is to complete it, publish it, and then you find half the industry says it's a load of rubbish. So what you try to do when you're carrying out a piece of work is find those people who might say that, involve them in the work, and understand what their issues are while you're doing it, and
Right.
try and address them. So that's why it's normal practice to involve groups like that.
Right. It sounds from what you've just said that you would involve an IAG as a form of internal and continuing peer review of the work as it was done. But was there another aspect to it, which is to understand what industry would tolerate and wanted?
I think it's important to understand the construction industry doesn't have one head. So what you would find out is which bits of the construction industry were for or against a particular issue. To imply that the whole industry would be for or against anything is never likely to happen from my experience. It's a very disparate industry.
I understand that, but I'm just trying to understand the role of the group, the IAG. Was it as a continuing peer review source to make sure that the research was being done on a technically sound basis, which is one thing, or was it a body of industry respondents who would tell you in more or less vociferous tones what they would and wouldn't accept, or what some of them would accept and some of them wouldn't accept? Or was it both?
It's principally the peer review thing. I think the way you're phrasing it makes it sound like the industry could dictate to the department what was or wasn't acceptable to it. I think that's probably the wrong language to use.
Right, what's the right language? And I don't use the word dictate, but
I
what
think,
would you say?
I think you would identify which bits of industry were likely to have their noses put out of joint. And so it's important, certainly for the policy officials, to understand that.
Very well. Let's go then to BRE 401392. This is a report given to Anthony Bird on the 27th of April 2001, which is a review of the fire performance of the external cladding systems. It's the report itself, and it's for the period 1st of April 2000 to the 30th of April 2001, prepared by Sarah Colwell. And we get that from page 2. We just look at that. And we can also see that this progress report was approved by Debbie Smith on the 30th of April 2001. Now, first of all, have you ever seen this document before? Did you see it at the time, do you think?
I might not have done. It's a progress report, so it's a sort of
Yes.
component of project management.
It is, but would you have seen it at the time, either in your role as BRE employee or role as secondee at the department?
The department would have asked me to review a project progress report. It's conceivable I might have been aware of it when I was working at BRE, but it wouldn't have been something I'd have paid a lot of attention to.
Why is that?
It's Dr. Colwell updating Mr. Bird on progress on the project. So it's an issue that the two of them would be very interested in.
Would you have had any input into drafting this?
I doubt it. Dr. Colwell might have asked me about something, but I think the things that I was working on, she was intimately involved in, so I doubt it.
Right. Now, if we go to page 5, please, and look under the heading Formation of the IAG, we can see there that 30 groups were invited to join the industry advisory group for this project, and they included representatives from manufacturers, and you can see manufacturers, rain screen systems, rendered systems and built-up systems, specifiers, and building owners and users. Can you help us about who chose the organisations to be invited to join the IAG?
I don't know. I mean, there's a fairly consistent sort of process about the way this is done. I can explain that, but I have no idea who made those decisions for this particular project.
Right. What was the basis on which these organisations and representatives of those organisations were selected?
Normal practice is to try and find a broad range of expertise and ensure, if you like, a fair representation. Again, one of the things that certainly the department would be very cautious of, and so would the researchers, is what you don't want is a group that's unduly influenced by one side or the other of an industry. And certainly when you're talking about thermal insulation, the industry was very much split into two, and there was an aggressive campaign by both sides. So, and even then, I mean, it got progressively worse. But that would have been at the forefront of their minds to make sure that there was fair representation there so that you could get their expertise and knowledge, but you wouldn't allow them to potentially influence the project in a way that would be sort of disproportionate.
Right. And what was the process for deciding on who was on the final list?
The projects I've worked on where I've been involved in this, it would be a joint exercise between officials in the department and the research team. So you would discuss with them who you thought was appropriate to give you that appropriate balance. And quite typically you'd also ask, once you'd formed the group, you'd also ask them if there was anyone missing. So sometimes they might say, oh, you know, we're all here, but where's Mr. X? And it might be that we didn't know he existed, but apparently he was quite an influential person in that particular sector.
Mr. Chairman, I've got about 5 more minutes on this document, and then I can finish it. Can you? Can I take the 5 minutes?
I think so. You could manage another 5 minutes.
I expect so, sir.
Yes, thank you.
Thank you.
Yes, very well.
I'm grateful, thank you. Can we get into page 5? You can see a bullet point list of the main group. And you can see there that it's reported that 27 of the 30 accepted the invitation to join. Yes? So 30 get invited, 27 accept. Yes?
So I'm trying to find the number 27.
It's spelt out, actually, rather than in figures, after the 3 bullet points.
Oh, yes, sorry.
27 representatives, yes?
Yes.
Yeah. And then if you go to page 9, we can see the members of the IAG group listed. There's a table there, and there they are. 5 members of the BRE staff, including you. You see that?
Yes.
Debbie Smith, Sarah Colwell, and a Dr. Jackman from the Loss Prevention Council, 3 government employees, including Anthony Bird, 3 local authorities, the BBA, CWCT, and then various industry associations. Was it envisaged that all aspects of the work on the project would be shared with the IAG, or did that group have a particular role?
As far as I'm aware, all of the aspects of the work would have been shared with them. I think, I suspect that there are quite a few local authorities there, which is unusual. Normally, you'd expect just like the local government association to suggest one. I think it's probably because of the exercise of carrying out a survey that they tried to get more local authorities involved to help them make contact with them.
How is the IAG kept up to date on the development of the work being done? Were there regular meetings or reports?
That's the usual process. Is that there would be meetings of the group from time to time to update them on the work, and documents would be shared with them as appropriate.
And this is one such, is it? A progress report?
Not necessarily. That would vary from project to project. I don't know who this was circulated with.
Let's go to page 8, and we go to the first bullet point under the heading Conclusions. And there it says, the formation and inaugural meeting of the IAG group has taken place. The group has been advised of the generic experimental programme, and responses appear to be generally positive. Do you remember attending that inaugural meeting?
No, I remember, I don't think I attended all of the meetings. I'm pretty sure I attended at least one.
Right.
But I don't remember which one it was.
And was Debbie Smith there at that meeting?
I'm sorry, I can't remember.
What about Anthony Bird, to whom you were submitting that progress report? Was he at that meeting? Remember?
I would expect he attended all of the IAG meetings.
Right. Do you remember whether there were any responses from any members of the IAG which were not positive?
No.
Right. We'll next turn to the literature review, but we'll do that, I think, on Monday. Mr. Chairman, is that a convenient moment for the day?
Yes, and you haven't taken up the whole of your 5 minutes?
No, I'll take the 2 minutes credit.
Yes. Very well. Well, Mr. Martin, we're going to stop there for today, but we're going to have to ask you to come back again on Monday, as I think you expected.
Yes, sir.
So we'll resume, please, at 10 o'clock on Monday. And as before, and particularly important with the weekend coming up, please don't talk to anyone about your evidence or anything relating to it over the break.
I understand.
All right. Thank you very much indeed. Would you go to the usher, please? Thank you very much, Mr. Minute. 10 o'clock on Monday, then, please. Thank you.